Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Hello, everyone. Thank you for joining another exciting podcast episode talking about something that is near and dear to both Gord and I's hearts. We're passionate about estate administration, and we're glad you're here.
Yeah, nice to podcast again with you, Jenna, and look forward to the topic and as always, our good conversations on all things estate administration.
Perfect. Well, what the heck is a 21-year deemed disposition, right? You know what, Lindy, let me rephrase that because we're not talking about that. Hold on.
And that allows me, I just realized I muted my phone, but my Zoom app was up. So the phone call rang there, you probably heard. So I exited that. Sorry about that.
Okay.
The phone ringing.
So what is the 21-year rule when it comes to trust? That's what we wanted to talk to about. Today, we get a lot of questions about 21 years when it relates to trust. A lot of people think that a testamentary trust can only last 21 years, and that is not true. So we wanted to debunk that myth and explain a few other concepts that you as a trustee, for those who are listening who are trustees, may come into subject with. So when we think of a 21-year, the most applicable explanation of the 21-year rule is really the deemed disposition of assets every 21 years of the assets held within a trust. So every 21 years, CRA requires any accrued gains of those assets to be captured on a tax return and taxes paid. And there's certain things you can do to try to further get tax benefits by allocating out to beneficiaries and things like that. But we just wanted to be clear that every 21 years there is a tax event, but the trust can continue after that point.
And in some cases, this is never going to come up because depending on if you're doing trusts for children, it could very well be that, well, they're not, it's not going to be around that long, right? If a child is 12 years old and it's a trust till age 21, we don't have this issue of the deemed disposition. But I think a lot of people, it does create a lot of confusion, right? About it's almost translates into saying, well, the 21 years, that's the end of the trust, which from a legal principle, once the trust is validly set up, it will carry on pursuant to the terms of the trust. So it has a particular life to it. Like if you set up a lifetime trust for a person, it's for as long as they live. And if they happen to live beyond 21 years from the date the trust was set up, then we have this tax event, right? This deemed disposition of everything within the trust. So then it creates these potentially negative or perceived negative consequences, right? Depending on, really comes down to what's in the trust, right?
Mm-hmm. Well, and there's another place where we see the 21-year rule applied, and that's in relation to the rule against perpetuities. And so would you be able to explain what the rule against perpetuities is for our listeners?
Yeah, so what's interesting is that in Alberta, there's a general rule against perpetuities that's been developed through case law, right? Judges have said, well, okay, we have this this issue that's there, but we do have the Perpetuities Act in Alberta. So the reality is a good way. So it's this legal principle that's also embodied, but the Perpetuities Act does say, well, the rule against perpetuities is still valid in Alberta. And really its purpose and design is to say, well, we can't just have property last indefinitely. be held in this trust structure indefinitely with no end, right? It has to be vested at some point, sort of balancing the policy issue of, well, the person who's creating the trust, oftentimes in a will, wants to say, well, I want to control what happens to it, but it has to be there for the benefit of the beneficiaries, and there has to be some certainty and avoiding any issues associated with it being around longer than it should be, so that there has to be a balance in those provisions. And as I said earlier, in a typical family situation, this is normally not a problem, but you could see in certain circumstances, if somebody is setting up a trust, and again, if you're an executor reading the will and you're going to go, we have this trust in here, and it begins to see that my goodness, this trust could be around for a long period of time, maybe there is a problem there, right? So it starts with an interest in property and this concept that it has to vest. Certainly no later than 21 years after the death of a life in being at the time the interest was created. So we get into these, okay, what is a life in being? Kind of refers to a person alive at the time the interest was created who can affect the vesting of the interest. So if you think about it, and then we've got different approaches in the legislation about how to deal with this. So if you had a trust that just went on indefinitely, leaving aside there may be uncertainty regarding the terms of the trust, which might make it invalid, that there may be a problem with regard to the rule against perpetuities, right? So it's something that is a more complicated legal principle that you would need some advice on. And presumably if you're going to a lawyer to help with the probate process or get some advice about what's my role on this, and particularly if you're the one that's going to be administering this trust because you're the one named in the will, that there is that concept. So just remembering there's a rule against perpetuities, and we need to deal with that, right? So the courts will generally take a wait and see approach, so that they'll try to determine, is this actually going to create a problem? Hopefully the will is drafted in a way that it doesn't create the problem, but if there is a problem there can be this sort of wait and see principle that may be applied to say, well, is it going to be a problem? Is it not? And there are some remedy provisions, right? Under the Perpetuities Act, you can go into the court and be able to amend the terms of the trust so that it doesn't offend the rule and create an invalidity of the trust. And again, given other, who may have an interest in this trust, whether it goes one way or the other, as the person managing it, you definitely want to ensure you're not getting yourself into legal trouble, and get some legal advice, and maybe proactively take some steps to try to remedy the problem in there, right? So that's really the issue that can be problematic on a poorly drafted trust, which may be part of the responsibility of the, if you're not only the executor, but also the trustee under the trust. But definitely being aware of the 21 years that we started talking about, it's definitely one of those dates to note in the calendar to say, well, as of this date, maybe by year 19 or year 20, I need to do some planning of what do I do with this trust, right? Do I do a distribution to beneficiaries to avoid this deemed disposition, or what else, what are my options? So usually it involves checking with the tax accountants or lawyers to get to be clear as to, well, what's going to happen in year 21, because it might involve writing a check to the receiver general. So that's usually the problem that people want to avoid, and then can look at various planning options for that.
Well, and at the time of recording this, there is the proposed legislation, of course, to increase the capital gains inclusion rate. Yes. And so, if you're a trustee contemplating whether to trigger gains maybe a little bit earlier than 21 years, that might be a subject to bring up with the accountant to determine if there is an opportunity to maybe get a little bit of a lower tax bill now rather than in a few months.
Yeah, no, absolutely with regard to that. So again, hopefully it's a problem solved at drafting, but if there's a concern regarding this property may not vest in the perpetuity period, then you'd want to get a legal opinion on that and figure out what the remedies might be and what fixes can be made to the trust. So you're acting in accordance with the law regarding how the trust should be administered.
And so, Gord, when you are advising clients who are planning their own estates and they have a desire to benefit generations, many steps down the line, what other strategies are available to them other than creating a trust that has this rule against perpetuities?
Yeah, in some cases, a private foundation could be an option. Now, the difficulty there, it's normally benefiting other, that's more on the charity side versus specifically benefiting the children. But ultimately, it may come down to saying, well, you have to give your wealth down to your immediate family, and then work on the communication about what's the best use of this money, and then almost the non-legal or the softer issues associated with let's educate the family on legacy planning and how you benefit that. If part of that legacy is sort of benefiting the community or focusing on education, then maybe something like a private foundation might be appropriate. Or otherwise just establishing, it's in something other than, this type of a trust, right? That goes on, that is going to create these particular legal problems, because then you wouldn't have the certainty to know that, well, this money is going to go for the intended purpose. If the trust is invalid, then it creates yet a further problem in that regard, right? So it is sometimes a challenge, particularly if there's that element of control. Well, I want to control what great grandchildren are going to be doing with this, with the funding, right? So sometimes you have to rein somebody in to say, well, we got to make it more immediate, because there's not some of the problems that arise when you go too far out is going to create the uncertainty that is a bigger legal problem, right?
Absolutely, which is all reason to rely on advisors and experts in this field to make sure that you're doing your role properly. And as you mentioned too, if you're a trustee managing a trust and you're approaching that 21-year rule, really just contact your accountant, your investment advisors to discuss possible strategies in minimizing that tax burden, whether that be allocating beneficiaries capital out of the trust before the 21 years. Or realizing some of those gains. But that's a good final comments, Gord, and always a pleasure. And thank you everyone for listening. We appreciate your support, and we look forward to talking and speaking next time.